Hello, it's Kevin Annett. This is part 2 of my lecture. We're looking at the solutions. What are we to do about this problem according to the natural sovereignty given to us by creation? Well, the subject of common law courts is very simple, and in fact it's contained within my book Establishing the Reign of Natural Liberty, which you can get through Amazon, but I'm going to summarize its main points right now. To establish common law courts that sit in judgment of rulers and their system of power is a revolutionary act, simply because to do so, we must first establish an altogether new political, legal, and spiritual jurisdiction, a new kind of direct democracy exercised by all the people. We must do so not only because the status quo is waging war on us, but because those existing institutions of government and the law have become unaccountable private corporations without any authority over us. It's a fact that a private corporation has surrendered its sovereignty and can only govern those who have entered into a contractual relationship with it, which is why we say over and over to people, never go into any crown court. Why? Simply because you have no need to. You are not in any kind of real or implied relationship with their corporation, and so you are free to create your own sovereign jurisdiction in the company of others. That is the basis of de jure common law courts, the fact that now only the people gathered in sovereign assembly can create a lawful de jure court of law. The obvious precedent that we rely on for this action occurred right in England in the year 1649, when the monarchy was legally abolished by a High Court of Justice created by the people in Parliament known as the Commons. The fact that the monarchy was unlawfully reimposed on England in 1660 by a military coup does not detract from its abolition by the people as a sovereign power. That sovereignty continues to function and allows anyone in England, Canada, or anywhere in the so-called British Commonwealth to reassert their power in public assemblies and common law courts created by them. And the English Crown, as a de facto but unlawful power, lacking de jure authority, has no right to challenge or oppose such a sovereign authority of the people, according to this Act of Parliament dated January 4th, 1649, and I quote, "The Commons of England, assembled in Parliament, declare that the people under God are the origin of all just power, and have the supreme authority of the nation. Whatsoever is enacted and declared law by the Commons alone has the force of law, and all the people are included thereby, with or without the consent of the king," unquote. The monarchy, in short, has no lawful authority over any of you. For this reason, over the past 4 years, our common law courts on both sides of the ocean have issued stand-down orders to all the agents and employees of the Crown, including its police, judges, and politicians, and placed them under our own common law jurisdiction. In short, like any great revolution, we are engaged, first and last, in a huge struggle for power. A fight not only for hearts and minds, but to establish the lawful reign of we the people over and against an illegitimate corporate tyranny. Now, it's essential that we understand this background if our efforts to create common law courts, because only they have the legitimacy and power that a new jurisdiction can grant. An alternative political power, in other words, must grant that jurisdiction first to any common law court, a sovereign self-governed assembly of at least 12 men and women in any country. Only when armed with the authority of this sovereign power can we answer the question, where do you get the authority to operate common law courts and sit in judgment of the system? So let me briefly summarize the steps in creating and operating such a jury-led court and how its judgments are implemented and enforced. Let's suppose you are convening a court to try suspected child rapists, traffickers, and killers, and those who are aiding and abetting them. Well, first we have to realize that the common law court is not simply a way to bring a judgment down, but it's a huge public forum. It's a stage where before the world we show the guilt of a system and its actors. The world, in other words, is the jury. We're not there just to convict a guilty party or institution, but to educate and mobilize the community, because only they will be the means of enforcing the verdict. But in terms of setting up the court, the first step is to compile the evidence and witnesses, and to name specific defendants who you wish to put on trial. Without that, no trial can occur. In a common law court, Allegations and conjectures are not enough. You need verifiable evidence that can meet the burden of proof that rests on you, the plaintiffs, who are the ones bringing the charges. For your job is to prove beyond any reasonable doubt that the accused are guilty of crime. Now, assuming you have such evidence, and there are specific persons or groups to charge, you have to present your general case in what is called a public claim of right, which sets forth your case, the defendants, the charges against them, and what it is you want. This claim of right includes a call for a jury consisting of at least 12 people. Your claim of right must be posted publicly. And again, we have a copy of such a claim of right here in our book. The actual common law court is then established not by you, but rather by the citizens of your community who respond to your claim of right. Those people must gather in a sovereign assembly and issue a declaration that declares that they are a self-governing body that is competent jurisdictionally and has the authority to convene such a court under natural law. On that basis, the jury volunteers are assembled and the following court officers are appointed. A court adjudicator or magistrate who oversees the court and gives legal advice to the jury. A public prosecutor to assist the plaintiffs if they so choose, and a public defender to assist the defendants if they choose. And finally, sheriffs, bailiffs, a court registrar, and a court reporter. Since the court must operate according to the rules of evidence, the defendants must be notified of the charges against them and be given the right to see the evidence against them and be judged by their fellow citizens. They also have the right to determine the content of the jury, and so a public summons for them to come to court must be issued against them, the ones who are being charged by the court, before the court can formally convene. Once the defendants either do so or decline, the magistrate then convenes what's called examination for discovery, which is really a pretrial conference in which both sides are invited to work out a resolution. If that fails, the plaintiffs then proceed with their case. That's you. Unlike other legal systems, a common law court is not run by a judge and lawyers, but by the jury members, who have the power to not only come to a judgment, but rule on, revise, and formulate the law itself. A jury can rule, for example, that the Crown of England and the Vatican are child-killing bodies without lawful authority, as occurred in the International Common Law Court in Brussels in February 2013, and you can see that at itccs.org. Such a verdict has binding power and can be used in other courts to issue arrest warrants against the convicted parties, including whole institutions and heads of church and state. The fact that a pope, a Jesuit leader, and 2 top Catholic cardinals resigned from their offices after being indicted and convicted by our common law court in Brussels is proof of its power. Now, once you as the plaintiffs begin your case, you have to operate according to due process, which means that the defendants are assumed to be innocent, and the burden is on you to prove that they are not. That fact alone makes it imperative that you have solid evidence to present that is not hearsay, but is direct and verifiable, like a living eyewitness who is party to the crime being named, like physical proof or primary documentation. Any documents or affidavits you rely on must be affirmed by having whoever signed them appear in court to testify under oath. If the defendants refuse to answer the summons and they don't appear in court, they have incriminated themselves by their very failure to respond, which is normally interpreted to mean that they do not contest or dispute the charges being made against them. At that point, a jury can lawfully find them guilty as charged because of their tacit admission of guilt. At that point, you have won your case by default, which of course is never as convincing as a verdict following a trial. However, if the defendants do respond to the summons and are present in court, they have the right to cross-examine your witnesses and contest any evidence you present. Then it is their turn to present their case. There is no restriction on what you or they can ask, or on what documents, people, or evidence you or they can call upon. Once both you and they have presented your cases, the jury retires to come to a verdict and a sentence. Neither the magistrate nor anyone else can interfere, alter, or influence the jury and its verdict and sentence. Once the verdict is issued, if the defendants are found guilty, the sentence is declared publicly and it must then be enforced. That is the real test and challenge of a common law court, whether it has the power to back up its decisions. That issue is especially important to us today, since those we are charging and putting on trial invariably are powerful people and organizations who may have official authority, power, and legitimacy on their side. How does one enforce a guilty verdict and sentence against them? Quite simply, by mobilizing and deputizing the community and the existing police forces as common law sheriffs and enforcement officers. This is done by the court immediately issuing a deputizing order to the people and the police that brings them under the authority of a common law court and makes them its agents. Armed with this order, anyone and any policeman can then arrest the convicted parties, seize their assets and property, and arrest any of their accomplices and protectors as accessories to the crime. Even the threat of doing so will often cause the most powerful guilty party to collapse, provided the actions of the court are public and visible enough and are pressed home. In other words, the common law court is not an end in itself, but that somehow instantly establishes justice. It's only beginning. It's a catalyst and a springboard that encourages we the people to establish that justice ourselves. Unless we all enforce the lawful sentence of the guilty, a lawful sentence against the child killers and others engaged in crimes against humanity, the verdict made against them will hang as lifeless and unenforced words. Now, I began this lecture by describing how deep-rooted crimes against children are in our culture and how they have been the basis of the power of the state, the church, and the corporatocracy all over the world. When we then call for action to stop and uproot the systemic torture and sacrifice of children, we recognize that realistically, we are issuing a call to rise up and bring down those powers that be. We are taking a revolutionary step. And like all true revolutions, we are challenging not only the material institutions of power, but the mindset and the spirit behind them that allows a few to control and exploit the many. That crime can only be reversed when the many awaken from their servitude and complicity through their own actions, and they reclaim their minds, their self-governance, and the world. The common law is an expression, but only one expression, of that ancient striving of an enslaved and fed upon humanity to reestablish the world and themselves according to natural law and its three laws. The unalienable truth that creation was placed in common for all people, that no one has any natural authority over another, and that we exist to live in peace, equality, and justice with one another. That law supersedes all others and all systems of thought and authority, which is why the common law and its courts have universal and ultimate jurisdiction over every other legal system. The test of this truth is what you and I will do today and tomorrow, so that the innocent will be saved and their killers brought down. Let us do so now, overcoming our fears and divisions that only profit the criminals in power. It doesn't take many of us to begin this revolution. We begin by lighting brush fires of freedom in the minds of men and women, by standing relentlessly by the ones who are targeted, and by reestablishing the rule of natural law in our world, against the tyranny of the corporatocracy and its puppet government and courts. For us to do so really will determine whether or not humanity rises or falls in the years ahead. We call upon all of you to take up this torch and carry it on. Thank you, brothers and sisters, and follow our work at itccs.org, murderbydecree.com. Contact our tribunal and its common law courts at itccsoffice@gmail.com. And I thank you.